Welcome to today's deep dive. We are incredibly thrilled to have you joining us.
Yeah, it's great to be here to get into this one.
For this session, we're going to explore a profoundly human problem that, well, eventually and often tragically, intersects with the cold, calculating calculus of the legal system.
It really is a tragic intersection.
It is, and I want to frame the core legal problem for you right at the outset. Think about this. When one spouse suffers a progressive, debilitating injury, exactly how does the law measure the collateral damage to the other spouse's life?
Right, because the primary victim is obvious.
Exactly. We all know what happens when someone is directly injured. They can sue for their medical bills, their lost wages, their own pain. But what about the person sitting next to them in the hospital waiting room?
The collateral damage.
Precisely. What about the partner whose entire domestic reality is completely upended? To explore how the legal system assigns a dollar value to a marriage, we are drawing on a highly illustrative source text today. We'll be looking at an appellate decision from the First Circuit Court of Appeal of Louisiana, a fascinating case titled Emery v. Owens.
And we have a very precise, structured, analytical path laid out for you today to unpack exactly how courts handle this complex emotional math.
Yeah, emotional math is a great way to put it.
This deep dive will rigorously examine the legal doctrine known as loss of consortium. We are going to tackle this in 3 distinct phases so you can truly master the concept.
Okay, lay out the roadmap.
First, we will dissect the fundamental legal elements required to actually prove a loss of consortium claim. Second, we will analyze the appellate standard of review for damage awards, which the law refers to as the quantum of the award.
Quantum, got it.
And finally, we are going to test these rigid legal rules with some highly visceral hypotheticals and then synthesize everything into an exam-ready diagnostic checklist that you can use to spot these issues in any fact pattern. Or, even just when reading the news.
Okay, let's unpack this. That sounds like a perfectly structured approach to a really thorny issue. Let's begin with that first phase, because I think a lot of people throw around legal terms without really knowing what they mean. Could you please define the legal concept of loss of consortium for us?
I certainly can. The general rule is that loss of consortium is a doctrine designed specifically to compensate a family member for the loss of love, companionship, comfort, and family services that are caused by another person's injury.
So it's not just one specific thing.
Exactly. Legally, we do not just look at this as one big amorphous concept. We break this doctrine down into 2 distinct testable elements. Element 1 encompasses the pecuniary components. These are the quantifiable material losses. Think of the loss of household services or physical labor that the injured spouse used to provide things that have a relatively clear economic substitute.
Like mowing the lawn.
Right. Then element 2 encompasses the non-pecuniary components. Those are the intangible, highly personal losses, such as the loss of love, companionship, affection, society, sexual relations, comfort, and solace.
I see.
Both elements represent a very real, compensable loss recognized by the law.
So just to make sure I'm synthesizing this correctly, the pecuniary component is basically the stuff you could theoretically hire someone else to do, like a landscaper to mow the lawn or a maid to clean the house.
Precisely.
But the non-pecuniary component is the irreplaceable human connection, the inside jokes, holding hands, the emotional support. That is a fascinating way to divide a relationship. To test this rule, I want to introduce you to the specific facts of Emery v. Owens, focusing specifically on the claims of a married couple, Wayne and Mary Bendley. Let's analyze Emery v. Owens. First, what are the legally dispositive facts?
The essential facts are as follows. Wayne Bendley was exposed to asbestos-containing materials while working as an insulator at Exxon's Baton Rouge refinery. This exposure occurred intermittently between 1965 and 1970.
Okay.
Decades later, as a direct result of breathing in those toxic fibers, he developed incurable asbestosis. The matter eventually went to a jury trial. The jury ultimately awarded Wayne $780,000 for his own physical injuries.
Got it.
But, crucially for our deep dive today, the jury also awarded his wife, Mary Bendley, $75,000 for loss of consortium. Following this verdict, Exxon appealed Mary's award.
And what was Exxon's argument there?
Exxon's core argument was that because the jury concluded Wayne had not yet suffered measurable pain and suffering through the date of the trial he was declining, but not yet in agony, Mary couldn't possibly be entitled to loss of consortium damages.
Wow. That is a really aggressive defense strategy by Exxon, essentially saying that because the husband isn't suffering enough yet, the wife hasn't lost anything legally recognizable. And what was the core legal issue?
The precise legal question placed before the appellate court was this. Was there a reasonable evidentiary basis to support the jury's award of loss of consortium damages to Mary Bendalee?
I see. It all comes down to the evidence of her loss. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the black-letter rule for loss of consortium, which explicitly requires an evaluation of two testable elements to justify an award. First, a measurable pecuniary loss of family services, and second, a measurable non-pecuniary loss of companionship, affection, and comfort.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, pecuniary components?
We can evaluate this using a structured sub-analysis. The sub-issue here is, did Mary lose measurable family services?
Okay.
The sub-rule dictates that the plaintiff must show an actual loss of services the injured family member would have otherwise provided. In applying the facts to this element, the court highlighted the medical testimony of Dr. Gomes.
And what did the doctor establish?
He established that Wayne's condition is an incurable respiratory disease that will progressively worsen over time. Furthermore, the court looked at Mary's testimony about a significant ongoing physical project clearing property that the couple owned together.
Oh, that's heavy labor.
Exactly.
Ah.
Because of Wayne's asbestos-induced shortness of breath, Mary now has to physically clear the land entirely by herself, while Wayne is physically relegated to just sitting and watching from the side.
That is heartbreaking.
It is. The application shows that as his lung condition inevitably progresses, she will have to assume even more of the heavy physical household duties. Therefore, the conclusion is yes, the first element regarding pecuniary components is clearly satisfied.
That paints a really vivid, tragic picture. You can just imagine the heartbreak of building a dream property together, and suddenly one partner is forced to swing the machete or drive the tractor completely alone while the other partner just struggles to breathe. It's a massive shift in physical labor. Understood. Now, what about the second element, non-pecuniary components?
For this intangible element, the sub-issue asks, did Mary lose companionship and comfort? The governing sub-rule states that there must be a demonstrable change in shared activities, comfort, or society between the spouses.
So how did they apply the facts here?
Applying the facts, the court looked deeply into Mary's specific lifestyle. She's a physically active, outdoorsy person. The couple used to share the simple daily ritual of walking around a local school track together.
Just a normal routine.
Right, it wasn't an extravagant European vacation, but it was their shared time. However, Wayne can no longer keep up physically, so they had to abandon this short activity entirely.
Wow.
The court emphasized that even though Wayne had not yet experienced what the law traditionally categorizes as severe pain and suffering, Mary's immediate, tangible loss of a shared active lifestyle squarely satisfies the legal requirement for lost companionship. Thus, the conclusion is yes, the second element is also satisfied.
So the law is saying that the loss of a simple evening walk is a compensable injury to a marriage, regardless of whether the primary victim is writhing in physical pain yet. That makes total sense. And after analyzing all the elements, what was the court's final conclusion?
Synthesizing the elemental analysis, the court concluded that a reasonable factual basis absolutely existed to support the jury's award for loss of consortium, and they firmly affirmed the propriety of that award.
Here's where it gets really interesting. That brings us to the next logical question for you, our listener, to consider. Even if an appellate court agrees that an award for the wife is generally justified by the facts, how do courts decide if the actual amount of money in this specific case, $75,000, is correct?
Right, the calculation part.
Yeah. Why not $10,000? Why not $1 million?
That requires an entirely different doctrinal analysis regarding the standard of review for damages. The general rule for reviewing damage amounts, which the court borrowed from a major precedent case called Young v. Maritime Overseas Corps, gives the trier of fact, which in this specific case was the jury, vast discretion.
Vast discretion.
Yes.
Yeah.
This rule for reviewing a quantum award is broken down into two strict elements. Element 1, the appellate court must determine if there's a clear abuse of discretion by the trier of fact, focusing strictly and solely on the particular injuries and their effects on this particular injured person.
Okay, so it's highly individualized.
Extremely. And then element 2, only if an abuse of discretion is found under the first element, the court may then look at prior, similar case awards to determine the highest or lowest acceptable point within the jury's discretion.
Before we jump into the case, let me quickly translate some of that terminology so we're all on the same page. When we say the quantum of the award, we are just talking about the actual dollar amount the jury wrote on the verdict form, right?
Yes, exactly.
And the reason the jury gets vast discretion is because they were actually in the courtroom. They saw Mary cry on the stand. They heard Wayne struggling to breathe. An appellate court is just reading a cold, sterile paper transcript months later, so they have to defer heavily to the people who are in the room. Let's analyze the quantum aspect of this case. First, what are the legally dispositive facts?
The essential facts regarding the quantum are straightforward. The jury awarded Mary Bendley exactly $75,000 for past and future loss of consortium. Exxon argued on appeal that this specific monetary amount was a clear abuse of the jury's vast discretion.
And what was the core legal issue?
The issue was the $75,000 award a clear abuse of the jury's vast discretion, given Mary Bendley's specific circumstances?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the two-element standard of review rule for damage quantums. Element first, the appellate court must determine if there is a clear abuse of discretion based solely on the specific plaintiff's particularized injuries. Element second, if and only if there is a clear abuse of discretion established in the first step, the court must then evaluate past damage awards from prior cases for comparison to adjust the amount.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, clear abuse of discretion for the particular plaintiff?
We begin our sub-analysis with the sub-issue. Was $75,000 an abuse of discretion, specifically for Mary Bendley? In its application, the court refused to view Mary as just a generic textbook plaintiff. They looked at her specifically as a physically active wife.
Right, the track walking, the land clearing.
Exactly. They coupled her immediate, already sustained loss of companionship, namely, not being able to walk the track or clear their land together with the medically proven incurable progressive nature of asbestosis. This progressive decline mathematically guarantees that she will shoulder the sole physical and emotional burden of his future care as his respiratory problems become acute.
Because it's only going to get worse.
Yes. The conclusion drawn from this application is that the jury carefully fashioned the award for Mary's particular injuries and the specific devastating effects upon her unique life. Therefore, no clear abuse of discretion occurred.
So the court is saying we aren't looking at what an average wife would suffer. We are looking at what this active, outdoorsy wife is suffering as she becomes a permanent caretaker. That really humanizes the legal standard. Understood. Now, what about the second element, comparative prior awards?
The sub-analysis here is very brief but highly structurally important for anyone studying appellate law. The application and conclusion are unified. Because the court definitively concluded under the first element that there was no clear abuse of discretion, the legal analysis completely stops.
It just stops right there.
Yes. The court explicitly states in its opinion that it does not need to, and in fact legally should not, resort to the second element of evaluating prior comparative case awards. The first step acts as a gatekeeper.
That is a crucial procedural trap to avoid. If there is no abuse of discretion, you never even look at what other juries did in the past. And after analyzing all the elements, what was the court's final conclusion?
The court affirmed the jury's $75,000 quantum, absolutely refusing to disturb the damage award on appeal.
Now that we have established how the doctrine functions in a traditional case of physical decline like asbestosis, I want to propose a visceral, memorable hypothetical to you, the listener, to really test the extreme outer limits of this loss of consortium rule.
I'm ready for it.
Imagine a scenario where a spouse suffers a severe workplace toxic exposure. However, unlike Wayne's asbestosis, this bizarre exposure doesn't cause any measurable physical pain, and it doesn't cause any mobility issues or shortness of breath at all.
Okay, totally fine physically?
Physically fine, yes. Instead, it severely and permanently damages their sweat glands, causing their body to permanently exude a powerful, grossly offensive odor, something akin to the smell of rotting garbage.
Oh, wow.
Yeah, and this odor absolutely cannot be washed away, surgically altered, or masked by any chemical or perfume. It is permanent and overpowering. How do the two legal elements of loss of consortium apply to this highly unusual situation?
What's fascinating here is that this incredibly vivid, albeit gross, scenario tests the doctrine perfectly. It completely separates the physical labor from the emotional connection. Let's run it through the framework.
Okay, lead the way.
Looking at the pecuniary element first, the quantifiable material losses might actually be minimal or entirely non-existent. Because the spouse has no mobility issues or physical pain, they can still completely perform physical labor. They can easily mow the lawn, they can wash the dishes, they can do the laundry, and fulfill all standard household chores without any physical limitation.
So under element 1, maybe 0 damages.
Right. However, when we analyze the non-pecuniary element, we see that this is where the major devastating damages lie. The loss of society and comfort here is profound.
Because of the smell.
Exactly. The couple can no longer go out to a nice dinner in public, they cannot realistically host friends in their home because of the overpowering odor, and they certainly cannot share a bed without extreme psychological and physical distress for the uninjured spouse.
It destroys the actual relationship part of the marriage.
The physical intimacy, the public companionship, and the basic domestic comfort of simply sitting on the couch together are completely destroyed by this condition. This perfectly illustrates how non-pecuniary damages alone can warrant a massive financial award, even in the total absence of physical incapacitation, loss of household labor, or traditional pain.
That is brutal, but it makes total sense. You're saying that even if the injured spouse can still physically wash the dishes and do the taxes, the complete destruction of their social and intimate life is what drives that non-pecuniary damage. It's the loss of the marriage's comfort, not just the labor.
Precisely.
Having explored both the dense case law of Emery and the outer limits of the doctrine through that hypothetical, could you synthesize all these complex rules into a step-by-step diagnostic checklist? Not just as a literal exam-taking tool, but as a mental framework for our listener to use if they ever read about a personal injury case in the news and want to understand exactly what a spouse is legally owed.
Absolutely. If we connect this to the bigger picture, analyzing any fact pattern for a loss of consortium claim requires you to rigorously follow this four-step framework.
Let's hear step 1.
Step 1, identify the claimants. You must explicitly spot the primary injured party first, and then correctly identify the spouse or immediate family member who is claiming the secondary collateral harm.
Okay, basic standing. What's next?
Step 2, check for pecuniary components. Scan the facts specifically for evidence of lost chores, physical labor, or household duties. You are looking for things like Mary Bendeley having to physically clear the land entirely alone because her spouse no longer has the lung capacity to help. Ask yourself, what labor is now missing?
Got it. And step 3.
Step 3, check for non-pecuniary components. Scrutinize the facts for evidence of lost intimacy, abandoned shared hobbies, or a diminished social presence. Look for a disruption in their daily joy, like the couple giving up walking the school track together, or the complete loss of public society in our toxic exposure hypothetical.
The emotional core and the final step.
Step 4, apply the quantum standard of review. If you are analyzing an appellate review of the actual dollar amount, you must start with the legal presumption of much discretion for the trier of fact. Ask yourself, is there a clear abuse based strictly on this specific person's lifestyle and unique circumstances?
And the procedural trap.
Right. Remember the procedural trap we discussed? Do not jump to comparing past cases or previous monetary awards unless the abuse of discretion is firmly established in that very first step.
I want to connect this entire deep dive back to you, the listener. Why should you care about the strict, sometimes clinical elemental analysis we just walked through? You should care because the legal system is essentially being asked to act as an actuary for the human heart.
That's a great way of putting it.
It is a system forced to assign a cold, hard dollar value to the intangible, invisible threads that bind a marriage together. The shared evening walks, the division of grueling physical labor, the quiet comfort of just sitting next to someone without saying a word. And I want to leave you with a final provocative thought to mull over as you navigate our rapidly changing modern world.
Oh, this should be good.
As technology exponentially advances, imagine a near future with fully immersive, photorealistic virtual reality environments. Imagine a scenario where physically disabled spouses, confined to a bed by something like asbestosis, can still strap on a headset and run, hike, or explore alongside their partners seamlessly in a digital space.
Wow, that completely changes the calculus.
Right. When that happens, will courts one day argue that the loss of physical companionship has been technologically mitigated? Does the rise of perfect virtual companionship inherently reduce the dollar value of real-world physical consortium? Will an insurance company argue that because a couple can still hike Mount Everest in VR, the spouse hasn't truly lost their companion? It is something fascinating for you to explore on your own. Thank you for joining us for this deep dive.